Hello everyone. Today we are going to discuss the topic lifting of the corporate veil under the company law. Let us start with the topic. From the legal point of view, a company is a legal person distinct from its members, as was held in Salomon versus Salomon and Company Limited case. This principle may be referred to as the veil of incorporation. The courts in general consider themselves bound by this principle. The effect of this principle is that there is a fictional veil between the company and its members. That is, the company has a corporate personality which is distinct from its members. But in a number of circumstances, the court will pierce the corporate veil or will ignore the corporate veil to reach the person behind the veil or to reveal the true form and character of the concerned company. Right? The rationale behind this the rationale behind this is probably that the law will not allow the corporate form to be misused or abused. In those circumstances in which the court feels that the corporate form is being misused, it will rip through the corporate veil and expose its true character and nature, disregarding the Salomon principle as laid down by the House of Lords. Right? Broadly, there are two types of provision for the lifting of the corporate veil. The first is judicial provisions, and the second is statutory provisions. The judicial provisions include fraud, character of company, protection of revenue, single economic entity, etc. While statutory provisions include reduction in membership, misdescription of name, fraudulent conduct of business, failure to refund application money, etc. So today, firstly, we are going to see the concept of veil of incorporation, then the meaning of the term lifting of the corporate veil, then the judicial as well as statutory provisions for lifting of the corporate veil with the help of various case laws. Right? Let's move further. Meaning of lifting or piercing of the corporate veil. So let's see. The human ingenuity, however, started using the veil of corporate personality blatantly as a cloak for fraud or improper conduct. Thus, it became necessary for the courts to break through or lift the corporate veil and look at persons behind the company who are the real beneficiaries of the corporate fiction. Right? Lifting of the corporate veil means disregarding the corporate personality and looking behind the real person who are in the control of the company. In other words, where a fraudulent and dishonest use is made of the legal entity, the individual concerned will not be allowed to take the shelter behind the corporate personality. Right? In this regard, the court will break through the corporate shell and apply the principle of what is known as lifting or piercing through the corporate veil. And while by fiction of law, a corporation is a distinct entity, yet in reality, it is an association of persons who are in fact the beneficial owners of all the corporate personality. In United States versus Milwaukee Refrigerator Company, the position was summed up as follows. A corporation will be looked upon as a legal entity as a general rule. But where the notion of legal entity is used to defeat public convenience, justify wrong, protect fraud, or defend crime, the law will regard the corporation as an association of persons. Right? In another case, Littlewood Mails Order Stores Limited versus Inland Revenue Commissioners, Denning observed as follows. The doctrine laid down in Solomon versus Solomon and Solomon Company Limited has to be watched very carefully. It has often been supposed to cast a veil over the personality of a limited liability company through which the courts cannot see. But that is not true. The courts can often draw aside the veil. They can often pull off the mask. They look to see what really lies behind. Right? They look to see what really lies behind. Let's move further. So let us see the judicial provisions or ground of lifting the veil. Fraud or improper conduct. Right? The courts have been more than prepared to pierce the corporate veil when it feels that fraud is or could be perpetrated behind the veil. Right? The court will not allow the Salmon principle to be used as an engine of fraud. The two classic cases of the fraud exception are Guilford Motor Company Limited versus Horn and Jones versus Lipman. In the first case, Mr. Horn was an ex-employee of the Guilford Motor Company, and his employment contract provided that he could not solicit the customer of the company. In order to defeat this, he incorporated a limited company in his wife's name and solicited the customers of the company. The company brought an action against him. The Court of Appeal was of the view that company was formed as a device, a stratagem, right? In order to mask the effective carrying on of business of Mr. Home. In this case, it was clear that the main purpose of incorporating the new company was to perpetrate fraud. Thus, the Court of Appeal regarded it as a mere sham to cloak his wrongdoings. In the second case of Jones versus Lipman, a man contracted to sell his land and thereafter changed his mind in order to avoid an order of specific performance. He transferred his property to a company. Russell Judge specifically referred to the judgment in Guilford versus Horn and held that the company here was a mask which Mr. Lipman holds before his face in an attempt to avoid recognition by the eye of equity. Therefore, he awarded specific performance both against Mr. Lipman and the company. Right? Let's move further. For the benefit of revenue, the court has the power to disregard corporate entity if it is used for tax evasion or to circumvent tax obligation. A clear illustration is Dinshaw McKinsey Petit Ray. So in this case, the SSC was a wealthy man enjoying huge dividend and interest income. He formed 4 private companies and agreed with each to hold a block of investment as an agent for it. Income received was credited in the accounts of the company, but company handed back the amount to him as a pretended loan. This way, he divided his income into 4 parts in a bid to reduce his tax liability, right? But it was held that the company was formed by the SSC purely and simply as a means of avoiding super tax, and the company was nothing more than the SSC himself. It did no business, but was created simply as a legal entity to ostensibly receive the dividends and interest and to hand them over to the SSC as a pretended loans, right? After this, we have one more thing, that is the enemy character, right? So, a company may assume an enemy character when person in de facto control of its affairs are resident in an enemy country. In such a case, the court may examine the character of person in real control of company and declare the company to be an enemy company. In Daimler Company Limited versus Continental Tire and Rubber Company Limited, a company was incorporated in England for the purpose of selling in England tires made in Germany by a German company, which held the bulk of shares in the English company. The holders of the remaining shares, except one, and all the directors were Germans, residing in Germany. During the First World War, the English company commenced action for recovery of a trade debt. Held the company was an alien company, and the payment of debt to it would amount to trading with enemy, and therefore the company was not allowed to proceed with the action. Right? Let's move further. Where the company is a sham, the court also left the veil where a company is mere a cloak or sham. Right? The company avoiding legal obligation, where the use of an incorporated company is being made to avoid legal obligation. The court may disregard the legal personality of the company and proceed on the assumption as if no company existed. Single economic entity. Sometimes, in the case of group of enterprises, the Salomon principle may not be adhered to, and the court may lift the veil in order to look at the economic realities of the group itself. In the case of DHN Food Products Limited versus Tower Hamlets, it has been said that the courts may disregard Solomon's case where it is just and equitable to do so. In the above mentioned case, the Court of Appeal thought that the present case was one which was suitable for lifting the corporate veil. Right? Here, the three subsidiary companies were treated as part of the same economic entity or group, and were entitled to compensation. Lord Denning has remarked that we know that in many respects, a group of companies are treated together for the purpose of accounts, balance sheet, and profit and loss accounts. Gover, too, in his book says there is evidence of a general tendency to ignore the separate legal group. However, whether the court will pierce the corporate veil depends on the facts of the case. The nature of shareholding and control would be indicators whether the court would pierce the corporate veil. The Indian courts have held that a single economic unit argument could work in certain circumstances. These circumstances would depend on factual control exercised. This view is strengthened by Supreme Court decision cited in Novartis versus Adarsh Pharma, in New Horizon versus Union of India, State of UP versus Renu Sagar were decided in 1988. Back in the year 1988 also, in Renu Sagar case, the court proceeded on the basis of the prior English law which had accepted the single economic unit argument. Then, thus, Renu Sagar case seems to support the conclusion that a single economic entity argument would succeed in India for lifting the corporate veil. Right? Let's move further. Let us see what do you mean by agency or trust. So here this will also help us to understand this lifting the corporate veil, where a company is acting as an agent for its shareholders. The shareholder will be liable for the acts of the company. It is a question of fact in each case whether the company is acting as an agent for its shareholders. There may be an express agreement to this effect, or an agreement may be implied from circumstances of each particular case. In the case of FG Films Limited, an American company financed the production of a film in India in the name of British company. The president of American company held 90% of the capital of British company. The board of Great Britain refused to register the film as British film. Held the decision was valid in view of the fact that the British company acted merely as the nominee of the American company. Right? Avoidance of welfare legislation. Avoidance of welfare legislation is as common as avoidance of taxation, and the approach of the courts in considering problems arising out of such avoidance is generally the same as avoidance of taxation. So, it is the duty of the court in every case where ingenuity is expended to avoid welfare legislation to get behind the smoke screen and discover the true state of affairs. Right? Public interest. The court may lift the veil to protect public policy and private transactions, contrary to public policy. The courts will rely on this ground when lifting the veil is the most just result. Where there are no specific grounds for lifting the veil, thus, where there is conflict with public policy, the courts ignore the form and take into account the substance. Right? So now let us look at these statutory provisions for lifting the corporate veil. Earlier we were dealing with the judicial provisions. Now it is the statutory provisions. So it is reduction of number of members. Under Section 45 of the Indian Companies Act 1956, if company carries on business for more than 6 months after the number of its member has been reduced to 7 in case of public company and 2 in case of private company, every person who knows this fact and is a member during the time that the company so carries on business after the 6 months becomes liable jointly and severely with the company for the payment of debts contracted after 6 months. It is only that member who remains after 6 months who can be sued. Right? Fraudulent trading. So under Section 542 of the Indian Companies Act 1956, if any business of a company is carried on with the intent to defraud creditors of the company or creditors of any other person, or for any fraudulent purpose, who was knowingly a party to the carrying on of the business in that manner, is liable to imprisonment or fine, or both. This applies whether or not the company has been or is in the course of being wound up. This was upheld in Delhi Development Authority versus Skipper Construction Company Limited. And After this, we have misdescription of the company. So, as per Section 147, Clause 4 of the Indian Companies Act 1956, provides that if any officer of the company or other person acting on its behalf signs or authorizes to be signed on behalf of company any bill of exchange, promissory note, endorsement, check, or order for money or goods in which the company's name is not mentioned in legible letters, he is liable to fine, and he is personally liable to the holder of the instrument unless the company has already paid the amount, right? And after this, we have premature trading. So these are the these are the statutory provisions for lifting the veil. So these are the situations where the veil can be lifted of the company, right? Premature trading. So it is another case. Another example for personal liability is mentioned in Section 117, Clause 8 of the English Companies Act. Under this section, a public company newly incorporated as such must not do business or exercise any borrowing power until it has obtained from the registrar of companies a certificate that has complied with the provisions of the act relating to the rising of the prescribed share capital, or until it has re-registered as a private company. It enters into any transaction contrary to this provision. Not only if it enters into any transaction contrary to this provision, not only are the company and its officers in default liable to pay fine, but if the company fails to comply with the obligations in that connection with 21 days of being called upon to do so, the directors of the company are jointly and severally liable to indemnify the other party in respect of any loss or damage suffered by reason of the company's failure, right? So we have another case, that is failure to refund application money. According to Section 69, Clause 5 of the Indian Companies Act 1956, the director of company are jointly and severally liable to repay the application money with interest if the company fails to refund the money within 130 days of the date of issue of prospectus, right? Holding and subsidiary companies. In the eyes of law, the holding company and its subsidiaries are separate legal entities, right? But in the following two cases, the subsidiary may lose its separate entity. Where at the end of its financial year the company has subsidiaries, it must lay before its members in general meeting not only its own accounts but also attached therewith annual accounts of each of its subsidiaries, along with the copy of the board's and auditor's report and a statement of the holding company's interest in the subsidiary, right? The court may, on the fact of a case, treat a subsidiary as merely a branch or department of one large undertaking owned by holding the company, right? Thus, now at the end, so this is the complete summary what we have gone through. Thus, it is abundantly clear that incorporation does not cut off personal liability at all times and in all circumstances. Honest enterprise by means of companies is allowed, but public are protected against this kitting and humbuggery. The sanctity of a separate entity is upheld only insofar as the entity is consonant with the underlying policies which give it life, right? Thus, those who enjoy the benefit of machinery of incorporation have to assure a capital structure adequate to the size of the enterprise. They must not withdraw the corporate asset or mingle their own individual accounts with those of the corporation. The courts have at times seized upon these facts as evidence to justify the imposition of liability upon shareholders. The act of piercing the corporate veil until now remains one of the most controversial subjects in corporate law. There are categories such as fraud, agency, sham, or facade, unfairness, and group enterprises, which are believed to be the most particular basis under which the law courts would pierce the corporate veil. But these categories are just guidelines and by no means far from being exhaustive. So these are the things which has really helped us to understand what do we mean by lifting the corporate veil. So in the cases of fraud, fraud, sham, facade, unfairness, and group enterprises, right? So in these cases, the purpose of lifting the corporate veil is to see the real person behind it. At times, what people see is that due to this principle, the wrongdoers, they were able to escape their liability. So in order to make sure that the real person who has done, or who has done wrong, even that person should come under the grip of law, so that that person could be punished accordingly. So that's why this, this lifting the corporate veil person has been incorporated in Indian Companies Act, in order to punish those wrongdoers who are really behind the actual fraud, right? Because of which innocent people suffer, right? So with this, we have come to the end of this topic. Thank you very much.